14 civic-minded Chicagoans filed a suit today in federal court challenging the early bird implementation by the City Council of the new ward map, changing the identity of the aldermen of thousands of citizens of Chicago without their consent. And the suit also challenges the map itself as violating the most basic principle of redistricting, which is one person, one vote. As this suit points out, there were all sorts of maps that were submitted that would have preserved minority voting rights just as much as the city's map, or even better, but would have divided the wards equally by population. The City Council, in the view of the plaintiffs, has to play by the rules. The rules are that once aldermen are elected, they should serve 4-year terms for the persons who elected them, and when you redistrict, you should follow the most basic rule of federal constitutional law and state law, which is one person, one vote, divide the wards equally by population. This is a suit that is brought by the League of Women Voters and by individual voters from all over the city. North side, south side, west side, all over. And they're all saying one thing, which is that the voters of Chicago should be allowed to choose their aldermen rather than having the aldermen choose who their voters are.
The basic principles of the League of Women Voters deals with representative government. And that is to promote an open governmental system that is representative, accountable, and responsive. In 2011, Chicago residents elected aldermen for 4-year terms. In 2012, the City Council redistricted the ward boundaries. Residents are now told that the aldermen representing the new 2012 ward boundaries within which they reside, not the aldermen elected from the ward boundaries as they existed for the election, represents them. The aldermen are not accountable to the citizens that are moved into redrawing wards because they did not elect the aldermen. Also, the aldermen may not be responsive to those who elected them, but who will not vote in that ward in the 2015 election. Thus, the aldermen are untethered from their electorate. We feel that the City of Chicago violated the rights of its residents, implementing the new ward boundaries before the 2015 City Council elections, and reassigning aldermen to provide services and represent the residents in the redistricted wards. We also seek a map based on one person, one vote, as outlined in the suit. Since we support a redistricting process which is timely, orderly, and meets the basic criteria relating to population, compactness, and continuity, and also the requirements of the 1965 U.S. Voting Rights Act and subsequent amendments. Thank you.
A resident of the 6th Ward, resident of the 9th Ward. I voted in the 6th Ward, and I was redistricted into the 9th Ward. Now I have representation of an alderman that did not vote for. I'm also a member of the NAACP here in Chicago. A map was developed with the NAACP, which represents one man, one vote. City Council has presented a map that does not depict that. There was a 0% deviation in the map presented by the NAACP, an 8.5% deviation in the map the City Council has accepted. We cannot accept that. Thank you.
And I'm from the 36th Ward, or previously what was the 36th Ward, now it's the 29th Ward. I guess I really am not sure who my alderman is, because if I make a phone call, they tell me I have 2. I'm here because Rahm Emanuel's administration invalidated an election and also the people's vote. By early implementation of the redistricting, the administration infringes on a basic tenet of democracy, and that is the ability to choose your representative. I think it's time that the leaders of Chicago be held accountable for their actions. As Helene said, We seek a fair map that is based on one person, one vote. Thank you.
In layman's terms, what's wrong with the map, first of all, is that it deviates from the principle of one person, one vote, mathematical equality. MALDEF, the NAACP, other parties submitted lots of maps to the City Council that provided for equality of population. This map has deviations of 8.7%, which means that the wards differ in population by thousands of citizens. And the suit also points out that many of the wards, and in particular the 15th, the 2nd, and the 36th, are so arbitrarily drawn. They're so the opposite of the legal obligation that a ward be compact. They're even violating the principle of contiguity, that the ward should be connected. The second ward is held together at some points just by an alley that's running from one area to the other. That those particular wards are arbitrary. There are a number of them that are arbitrary. The whole map has to be redone. Why was this done? The complaint sets out the reason, and there's not a real dispute about it. Patrick O'Connor said it on the floor of the City Council. The map was drawn the way it was. The deviations occurred the way they did because it was important to get 41 members of the City Council to think, I'm secure in here. There would have been competing proposals presented probably from the progressive aldermen, the independent aldermen, and the majority aldermen, and the voters would have decided what the map was. To prevent that from happening under state law, it's necessary to get 41 members of the City Council to sign on. So this map was put together in such a way as to get 41 people to sign on to it. That may be politics, and that may be the Chicago way, but there are rules of law that have to apply. One of those rules is one person, one vote. Another rule is you don't put in the map early so that you have access to the voters that you're going to be in front of in 2015 if those voters haven't consented to it. So we're doing two things in this suit. Stopping the early implementation of these ward boundaries and stopping aldermen who are writing off their old constituents and saying we're representing new constituents. And we're demanding that there be a neutral, impartial process that will create a new map that preserves minority voting rights equally or better than the existing map and divides the wards equally by population.
Will you seek an injunction to keep some committees from using the new map?
Yes.
How many Black and Hispanic wards would there be if it was done in the way that you consider fair?
There would be at least the same number as the existing majority Black and majority Hispanic wards.
In spite of a 180,000 drop in the Black population?
Yes. There were maps submitted by the Chicago NAACP and MALDEF that preserved, well, the NAACP actually had more majority Black wards than the existing map. So they're interested in promoting a map that is lawful, divides the wards equally by population, and increases minority
Well,
representation.
how is that fair? If the city loses almost 200,000 Black population to keep the same number of Black wards, is that a fair way to go about this?
The question is whether or not these are majority wards. You know, there's all sorts of ways that the wards could be divided up so that it is fair and protects minority voting rights.
It's not new that incumbents try to protect themselves. Every map in the world is done that way, at the state level and congressional level, everywhere. So, I mean, this is the way it's been since the beginning of time.
That doesn't mean it's right. And in this particular case, this has been accepted for so long that in this particular case, the city council majority felt that they could violate all the rules. Well, there are some limits on gerrymandering, and one of the limits on gerrymandering is one person, one vote. That is the rules that have to be followed in U.S. congressional elections, and they ought to be followed in state and local elections as well.
Do you have a precedent for a suit like this being successful at the local or state level?
Cox versus Larios.
What's that?
It's a Supreme Court decision from 2003.
In what city did that happen?
It was in Georgia, and the Supreme Court affirmed a decision where the district court didn't allow any deviation from one person, one vote. But more broadly, the real core precedents are Baker versus Carr and Reynolds versus Sims. Those are the decisions that Justice Brennan wrote in 1962 requiring one person, one vote.
Are you worried that this is going to lead even more confusion? You've got the 2011 map. People are being told that they should use the 2015 map, and now you're raising the specter of another map being brought into play.
This suit is going to end the confusion.
Well, but couldn't they say we
People are
were trying
confused
to...
now. They don't know who their alderman is. They don't know whether they're in, they don't know whether they're in the 6th Ward or the 9th Ward. This suit is to end the confusion.
Couldn't they say they were trying to save the city money through the costly fight with the referendum and the lawsuit and all that? We've seen those fights that cost tens of millions of dollars.
I'm not sure I understand the question. You mean
Well,
the
if
fact
the
that there
alderman-
was a referendum that would be expensive for the
No,
city?
and it was. If the alderman kept saying, we want to avoid this marathon battle that would cost so much money at a time when we don't have it. That's what they said, in addition to the other things that you said.
Well, the way to avoid a marathon battle is to follow the law. And the law is one person, one vote. It's pretty simple. It's the easiest cost avoidance system in the world. Follow the law.
Are there any of the aldermen who would be, who lost this game of musical chairs, who are endangered incumbents, who are joining you in this or behind the scenes?
Oh, I think that there are aldermen who support this case, but I want to emphasize there aren't any aldermen who are plaintiffs, and we are not representing any aldermen in this lawsuit. This is on behalf of the League of Women Voters and civic-minded citizens from all over the city.
Thank you.